Module 3. Topic: the liability that you as a seller server can be accountable for. Information to be covered in this module. Number 1. Dram shop lawsuits. Number 2. The potential legal consequences of overservice. Number 3. What you can be sued for. Number 4. Consequences for serving an intoxicated individual. Number 5. Consequences for serving a minor. Number 6. Who can sue you? Number 7. Damages you might have to pay. Number 8. Criminal liability. Number 9. Strategies for protecting yourself and your employer from any kind of liability. Number 10. Using a logbook. And number 11. An alcohol serving policy. It is important for you to understand that there's more to serving or selling alcohol than most realize. This module will help you in your serving-selling decisions. If you serve or sell alcohol to an intoxicated person, you could be held accountable in the court of law stemming from the Dram Shop Act. Dram shop liability refers to the body of law governing the liability of bars, liquor stores, and other establishments that serve or sell alcoholic beverages. Dram shop laws establish the liability of establishments from the sale of alcohol to visibly intoxicated persons or minors who, as a result of being sold or served alcohol, cause death or injury to third parties through alcohol-related car crashes and other accidents. These laws were enacted in order to protect the general public from the possible hazards of serving or selling alcohol to minors and intoxicated patrons. Let me break it down for you. There are 3 parties in a dram shop lawsuit. The first party is the drinking party, your customer. The second party is the serving or selling party, you and your establishment. The third party is the person or property outside of the alcohol transaction, the victim. For example, Mrs. Jones comes into your establishment and you serve her alcohol until she becomes intoxicated. She leaves and you do nothing to assist her in finding a safe way home. Mrs. Jones crashes her car into Mr. Smith's car and hurts him. Mr. Smith is now able to sue Mrs. Jones, you for serving Mrs. Jones, as well as the establishment that you work at, and he will probably win. Here's a quick trip to law school for you. A tortfeasor, a tort is a civil wrong, as a crime is a criminal wrong. The most likely civil claim that will be brought against you is negligence. This tort requires 4 elements. One is a duty to another. This is created by common law. Common law is decided as the common to the area of where you reside that if you served alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Number 2, was there a breach of this duty? Did the server of the alcohol do nothing to stop that person from driving or walking away? Number 3, proximate cause. Was it reasonably foreseeable that the person who was intoxicated might have an accident while driving or walking? Number 4, damages. This includes the intangibles such as pain and suffering, loss of consortium, loss of lifestyle, and emotional distress, as well as tangible losses such as medical bills, lost wages, and damage to property. All of those involved in the alcohol transaction can be named in the lawsuit. The manager, the host, the hostess, the valet, the attendant, the bouncer, etc. will all be named in the lawsuit. A plaintiff's attorney only has to persuade the jury that it is more probable than not that you breached the duty and you caused an injury. This is commonly argued as just tipping the scale or proving your case by 50.1%. Under Arizona law, you can be ordered to pay damages even if you are only 1% negligent. The jury will be asked to apportion negligence among all parties and non-parties. Drunk drivers are typically not parties in the lawsuit against the bar because they settle or have no insurance. The jury will apportion fault to every party that was negligent and decide the total cost of the injured party's damages. You will then be ordered to pay your percentage of the damages. Thus, you can be 1% at fault and still have to pay the injured party. If the injured party is the innocent bystander, a jury typically will not apportion any fault to the injured party. If the injured party is the drunk driver, and there have been times the drunk driver sued the bar or bars that allegedly overserved them for his or her own injuries, you may still be ordered to pay money to the drunk driver. An Arizona jury can decide not to award any damages to an injured person if the injured person was 51% at fault for his or her own injuries. The drunk driver, however, can recover damages even if he or she was 99% at fault unless the jury decides not to award any damages. If the jury finds the drunk driver was less than 50% at fault, you will have to pay the drunk driver for the percentage of negligence apportioned to you. The overwhelming majority of lawsuits settle, as many as 90%. A law journal has estimated that 80% of these lawsuits will be settled out of court for $100,000 or more. The cases have multiplied by 300% in recent years. What are the potential legal consequences of overserving? There are three: administrative consequences, civil consequences, and criminal consequences. Administrative consequences: your employer loses his license and you lose your livelihood. Civil consequences: you lose your home, your life savings, and whatever else you've accumulated. Criminal consequences: you pay a fine and go to jail. The civil consequences require more in-depth treatment. When looking at the civil consequences, there are a few specific questions to ask. What can I be sued for? Who can sue me? What types of damages will I have to pay? Until 1983, Arizona did not allow a lawsuit against a liquor licensee for overservice. That all changed when the Arizona Supreme Court ruled in 1983 that a tavern owner, which is really any liquor licensee who sells to retail customers, including grocery stores and convenience stores and drugstores, could be sued by its own customer or the public for injuries sustained off the premises that were caused by an intoxicated customer. As a result of the 1983 Arizona Supreme Court ruling, a liquor licensee in Arizona can be held liable for damages if the licensee or their employee serves an underage person or an intoxicated person if they knew or should have known that such conduct would create an unreasonable risk of harm to others. The Arizona legislature attempted to minimize the effect of this court decision by passing ARS 4-311 and 312 in 1986, which attempted to limit liabilities to selling to obviously intoxicated customers. Under ARS 4-311, a licensee is liable for property damages and personal injuries, including death if the jury finds that the licensee sold alcohol to either: number one, a purchaser who is obviously intoxicated, or number two, an underage purchaser without requesting identification and containing proof of age, or with knowledge that the person was under the legal drinking age. The licensee is liable if the purchaser consumed the alcohol and the consumption of the alcohol was a proximate cause of an injury, death, or property damages. The legislature defines obviously intoxicated as follows: inebriated to such an extent that a person's physical faculties are substantially impaired and the impairment is shown by significantly uncoordinated physical action or significant physical dysfunction which would have been obvious to a reasonable person. The Arizona legislature also attempted to prevent people from suing liquor licensees for any injury to a consumer or purchaser of alcohol or any other person present with the person when he or she consumed the alcohol. Arizona courts, however, held that the legislature could not limit a liquor licensee's liability in either of these ways. Thus, an Arizona liquor licensee can be sued by customers or strangers for violating ARS 4-311 by selling alcohol to an obviously intoxicated person, or for violating the common law by selling alcohol to a person when the licensee knew or should have known that such conduct creates an unreasonable risk of harm to others. As a practical matter, most plaintiffs will sue for both the statutory violation and the common law violation. A plaintiff, however, only needs to prove one of these two claims. Important things to remember. Number one, you can overserve someone even if you have no evidence that they have had anything to drink beforehand. The only question is whether a reasonable person would believe that you should have not served the person. Under the common law theory, the intoxication does not have to be obvious. Number two, if you believe that a customer is obviously intoxicated when they enter the business, after they've been drinking, or if the customer is disorderly, Arizona law requires that you make the person leave the premises within 30 minutes from when you knew or should have known that the person was obviously intoxicated or disorderly. In other words, the liquor licensee has up to 30 minutes in order to find a safe ride to transport the intoxicated person off the premises. If a person is disorderly, however, the licensee should ask them to leave immediately. Number three, any person who seems intoxicated or who has been served an unreasonable amount of drinks should not be served any further alcohol. Counting the number of drinks served should be a general tool you use to determine when alcohol service should cease. What if the person I overserved does something other than drink and drive? If you serve someone who is obviously intoxicated and that person assaults someone else, you will be liable to the person who is assaulted if you knew or should have known that the person might act violently. This also includes sexual assault. Several Arizona courts have found that a liquor licensee is liable, at least in part, for injuries caused by acts of violence, ranging from shootings to physical assaults. Juries have awarded damages in excess of $1 million. Many more cases have been settled for several hundreds of thousands of dollars. Now what happens if you serve a minor? Well, serving any liquor to a minor can lead to a civil liability lawsuit for any foreseeable act that the minor does. You could even be liable to the minor if that minor hurts himself or herself. But you can protect yourself from some liability if you demand to see identification from the person. You will want to, number one, examine identification in order to determine whether that identification reasonably appears to be a valid, unaltered identification that has not been defaced. Number two, examine the photograph in the identification and determine that the person reasonably appears to be the same person in the identification. Number three, record and retain a record of the person's identification on a particular visit. Records should be kept for a minimum of 2 years under liquor laws, but you should keep the record for 3 years in case a lawsuit is filed. The identification you demand from your customer must be only one of the forms of identification that is acceptable in Arizona. Both acceptable forms of identification and types of records to be kept will be covered extensively in Module 8. ARS 4-241. This defense is used in response to a statutory violation, but it should be equally available in response to a common law claim. This defense is not valid if the person serving the underage person knows that the person is underage. Is there anything you can do to avoid being liable? Yes. Do not serve or sell alcohol to anyone who appears intoxicated or being disorderly. Do not serve too much alcohol to someone based on the amount of time the person is in your business. Do not serve or sell alcohol to anyone who is a minor.